go ahead with preference shares provisions. I like the condition. The first condition is that we have to see articles of association. Second condition is that we have to pass a special resolution. Have you highlighted authorized articles of association? Go to the second condition. Preference share can be issued only when there is no subsisting default in the redemption of preference shares issued earlier or in the payment of dividend due on any preference shares. So we can issue preference shares only when there is no subsisting default for redemption of earlier preference shares or even dividend. The resolution which we have to pass for issuing preference shares is special resolution, and in that special resolution, what matters, what are the things that we have to disclose, that is given here. Priority with respect to payment of dividend, participation in surplus fund. So basically we just have to mention which type of preference shares we are going to issue. I hope you are aware of the types: convertible, non-convertible, then redemption period. Now it is restricted to 20 years, so we have to mention within how many days we are going to redeem the shares. Participating or non-participating, cumulative, non-cumulative. So the type that the company is willing to issue, that details we have to disclose in the resolution. Okay, next, payment of dividend, whether it is on cumulative or non-cumulative basis, conversion, what will be the voting rights. So if you remember, if we fail to pay dividend to preference shareholders for a period of 2 years, then in that case, preference shareholders will acquire all the rights which are applicable to equity shareholders. So even voting rights will be applicable to preference shareholders because company failed to pay dividend on preference shares for a period of 2 years. So these are the matters that we have to disclose in the resolution. Now we go to the explanatory statement disclosures. To revise once again what explanatory statement is, it is a statement that gives details to the shareholders, and depending on those details, shareholders will take the decision whether to pass the resolution or not to pass. So in the explanatory statement, you will find all additional disclosures with respect to the resolution. And these additional disclosures will help the shareholders to understand the purpose of the resolution and to understand the contents and the reason behind the resolution properly. So explanatory statement is always attached to special resolution, and you will find different disclosures that we have to give under different sections in the explanatory statement. For issue of preference shares, what we have to give is size of the issue, number of preference shares to be issued, again nature of shares depending on the type, objective. This clause, I think everywhere it is same. We just have to give reason for passing any resolution under any section. Manner of issue, price at which shares are going to be issued, basis on which the price has been arrived, terms of issue, terms of redemption, dilution, expected dilution in the equity share capital upon conversion of preference shares. When the shares are going to be converted, and at that time number of equity shares are going to be increased. So the EPS for equity shareholders is going to be changed. That's why they just have to give, we just have to give in the explanatory statement the expected dilution in the equity share capital on conversion of preference shares. We have to maintain register of members to contain the particulars of preference shareholders. When a company issues preference shares, the register of members maintained under section 88 shall contain the particulars in respect of such preference shareholders. Like we are maintaining ROM for equity shareholders, it's the register of members. So preference shareholders are also in fact members of the company. So whenever we are issuing preference shares, preference shareholders become the members of the company and their name should be included in the ROM. Redemption, we have seen above, the redemption period is restricted to 20 years, and for infrastructure companies redemption period is exceeded to 30 years. This redemption will happen either at the option of the company or at the option of the shareholder, or at a fixed time or on happening of particular event. See when redemption will happen. First, at the fixed time. So that time is the time that we have already mentioned in the resolution. That can be any time before 20 years, correct? So for example, in the resolution, we have mentioned that preference shares will be redeemed say after 5 years. So redemption will happen at a fixed time, that is after 5 years, or it can happen at company's option, or it can happen at shareholders option. So whenever company decides, or whenever company has funds, company will uh, opt to redeem the preference shares, but that is again anytime within 20 years. Or the third is shareholders option. Whenever shareholder needs money, shareholder will come to company and come ask his money. So and that also should happen anytime during 20 years. So ये क्या कैसे redemption करने वाले हम लोग, that thing we have to mention in the resolution and in the explanatory statement, whether it is going to be at a fixed time or whether it is going to be at company's option, how what could be the method that we are going to use, that we have to mention in the resolution. Okay, now we go to the procedure. Is just simple procedure for issue of preference shares. The first thing everybody knows that we have to see is the articles. We have to see the provision in the articles of association. If you find that articles is silent on this, then we have to include this provision first in the articles, and for that we have to alter our articles of association by passing special resolution and by filing MGT 14, because we are passing special resolution. So after that, we have to issue preference shares in the board meeting. So we have to call board meeting, pass board resolution. After that, highlight general meeting. We have to call general meeting, and we have to also send explanatory statement. If the company is listed company, we have to intimate to stock exchange at least 2 working days in advance of the board meeting in which we are going to take a decision of issue of shares, so that general public will also come to know that there is going to be issue of preference shares. This is in order to avoid insider trading transactions. Anyway, next, in the general meeting, what we are going to do, we are going to pass special resolution. And as I told you earlier also, whenever in the act, whenever in the whole act we are going to pass special resolution, we are going to file MGT 14. This everybody has to keep in mind. It's very simple. For whatever reason we are passing special resolution, we have to file MGT 14. Okay. In case of OPC, for the purpose of passing ordinary resolution or a general meeting resolution, any business which is required to be transacted at AGM or other general meeting by means of ordinary or special resolution, it is sufficient if the resolution is communicated by member to the company and entered in the minutes book. Because in case of OPC there is just one member, and we have seen that to conduct a meeting you should be needing at least two members, meeting of two minds. That's why in case of OPC, the one member who just has to sign that resolution and give the resolution to company, which the company will enter in the minutes book, and that is how resolution will be passed in OPC. Now, whenever we are going to allot the shares, there's one return of allotment that we have to file. Do you remember the form in which we are going to file return of allotment? Yes, it is PS3. Okay, PS3 we have to file within 30 days. So for allotment, we have to again take a board meeting and allot the shares. After allotment, we have to file PS3. After filing PS3, the standard procedure that we have to follow is to issue share certificates, to register, update the register of members. If the shares are held in demat mode, then we don't need to issue share certificates. In that case, we have to intimate the depository. Okay, यहाँ तक समझा? Within how many months you are going to issue share certificates? 2 months. Then comes redemption. Now we have issued the preference shares. Now we are paying dividend on preference shares. Now it's time for redemption. We have seen that redemption will happen either at fixed time or happening of a particular event, or at any time at company's option, or at any time at shareholders' option. Whenever company is going to redeem preference shares, company has to issue, no, not issue, company has to file Form SH7 with ROC along with the altered memorandum. Okay. Uh, Altered memorandum, if at all there is no authorized capital and you have increased the authorized preference share capital, in that case you have to alter memorandum, and that's why you have to file that altered memorandum copy also. Point here to remember, after redemption the form that we have to file is Form SH7. This allotment we have seen, period of 2 months, this we have seen. Okay, and for redemption, just write down at the left side margin. For redemption, do not forget to create CRR. Okay, for redemption, do not forget to create CRR. We have to create CRR while redemption. So what we have studied in section 55 is that we have to see the articles of association. If there is no default, then only we can issue preference shares. Then the redemption period is 20 years. Infrastructure companies have to 30 years. Whenever we are passing special resolution, we have to file MGT 14. Whenever we are allotting preference shares, we have to file Form PS3. After redemption of preference shares, we have to file SH7. ये सारे फॉर्म्स याद रखने हैं क्या? Yes, ये सारे फॉर्म्स हमें याद रखने हैं. Redemption will happen at by three ways, either at a fixed time or at company's option or at shareholders option. Whenever we are redeeming the preference shares, we are creating CRR. Do not forget subsection 3 of section 52, which talks about shortage of funds, and if at all company could not repay the preference shareholders in monetary terms, then company has to take the consent of 3/4 in value of preference shareholders and file petition with NCLT, take the order of NCLT, and can issue equivalent number of further preference shares, which will be deemed redemption of earlier preference shares. This is section 55.